The final vote is 50-50. Every senator has voted. The chamber is split exactly down the middle on which slate of electors from state X should be counted. Under the Electoral Count Reform Act, a tied Senate vote means the objection fails. The disputed slate is counted. But which disputed slate? Because there are two. And the act doesn't specify what happens when both slates are disputed and both objections fail simultaneously. The tiebreaker under the Constitution is the presiding officer, the vice president, who is also in this scenario on the ballot. That is not a plot twist inserted for drama. That is the actual constitutional structure of how this gets resolved or doesn't. Before we get into the mechanics of how that moment becomes possible, we need to establish something clearly. This is a speculative scenario, a structured hypothetical built on real constitutional architecture. The Electoral Count Reform Act is real. The legal ambiguities we're going to walk through are real. The historical precedents are real. What we're doing here is stress testing the system against a combination of circumstances it was never explicitly designed to handle. Think of it less as prediction and more as a constitutional pressure test, the kind that law professors run in seminars but rarely make it into public conversation. So let's build the scenario from the ground up. The year is a near future presidential election cycle. The result comes down to a single state. We'll call it Arbor. Arbor is a swing state with a divided government. The governorship is held by one party. The state legislature is controlled by the other. The popular vote margin in Arbor is 1,100 votes out of 6.2 million cast. Both sides immediately lawyer up. Recounts are demanded, initiated, and completed. The results hold, but only barely, and only according to one counting methodology. A separate methodology, equally defensible under Arbor's state statutes, produces a different winner. Here is where the architecture starts to fracture. Under the Constitution's Article 2 and the relevant provisions of federal electoral law, states have broad authority to determine how their electors are appointed. The governor of Arbor, relying on the certified recount under Methodology 1, signs and transmits a certificate of ascertainment naming Slate A, 12 electors pledged to candidate 1. 3 days later, the state legislature, relying on a concurrent resolution passed along party lines citing Methodology 2, transmits its own certificate naming Slate B, 12 electors pledged to candidate 2. Both certificates arrive in Washington. Both are signed by constitutional officers of Arbor's state government. Both cite legal authority. Neither is obviously fraudulent. Neither is obviously valid. This is the exact scenario the Electoral Count Reform Act of 2022 was written to prevent. And it almost does. Almost. The SCRA tightened the definition of a lawfully certified slate. It specified that the governor's certificate carries presumptive validity. It raised the threshold for congressional objections from one member of each chamber to 1/5 of each chamber. It was, by most assessments, a serious and substantive reform. Senator Susan Collins and Senator Joe Manchin, the bill's primary architects, described it as closing the loopholes that had made January 6th possible. What the ECRA did not resolve, because the drafters considered it an edge case too narrow to legislate, is what happens when a state's own legal framework produces two simultaneously valid certifications from two separate constitutional actors, each operating within the scope of their own authority. The act presumes one authoritative state voice. Arbor, in our scenario, has two, and they are saying opposite things. The case goes to federal court within 48 hours of the second certificate's arrival. It moves faster than any case in modern judicial history because it has to. The Electoral College meets on a fixed date. The courts have a closing window. District court, appeals court, emergency application to the Supreme Court, all within 3 weeks. And here's where the scenario turns from complicated to genuinely unprecedented. The Supreme Court takes the case. It hears expedited oral arguments. It deliberates for 72 hours, and it issues a ruling of 4-4. A tied Supreme Court in standard federal jurisprudence produces an affirmance by default. The lower court ruling stands. But here, the lower courts themselves were split. The district court ruled for Slate A. The appeals court reversed, ruling for Slate B. A 4-4 Supreme Court tie on the appeals court ruling means the appeals court decision, Slate B, technically stands, except that 2 of the 4 justices in the majority explicitly wrote that their vote was procedural, not substantive. They believed the court lacked jurisdiction to decide the merits at all. 2 others wrote that Slate B was correct on the merits. 4 justices dissented entirely, arguing Slate A was the valid slate. The result is a ruling with no majority reasoning, no binding precedent, and no clear answer to the underlying legal question. What it does produce is a default. Slate B is technically the operative slate under the affirmance. Congress must now count it. Congress convenes on January 6th. The joint session begins. The Vice President presides as required by the 12th Amendment and confirmed by the ECRE. When the arbor certificates are reached, the clerk reads both into the record. Under the ECRE's objection threshold, 1/5 of each chamber has signed objections to both slates, Slate A and Slate B. Both objections are formally raised. The joint session splits to consider them separately, as the Act requires. The Senate votes first on the objection to Slate B, the one the Supreme Court technically validated. The vote is 50 to 50. Under the ECRE, a tied vote means the objection fails. Slate B survives the objection. Fine. But then the Senate votes on the objection to Slate A, also 50 to 50. That objection also fails. Slate A also survives. The Act does not contain explicit language for this outcome because the Act was written assuming only one slate would be before the chamber at a time. The provision that says a failed objection means the slate is counted was written for a world with one disputed slate. Not 2 simultaneously surviving objections, not 2 slates, both of which have cleared the objection process. The joint session reconvenes. Both slates are technically unchallenged. The presiding officer, the Vice President, must now determine which certificate to count toward the final tally of 270. If you've been tracking the depth of what we're working through here, this is a good moment to note that this kind of granular constitutional analysis rarely surfaces in the 24-hour news cycle. If you want to keep tracking these structural pressure points as they develop, subscribing to this channel is genuinely the most efficient way to make sure the algorithm sends you signal instead of noise. Now, back to that rostrum. The Vice President's role under the 12th Amendment is to open the certificates and count the votes. The ECRE clarified in response to the events of January 6, 2021, that this role is ministerial. The Vice President does not have unilateral authority to reject or delay the count. What the Act does not specify, because no one thought it needed to, is what the ministerial role looks like when the minister is holding 2 valid, unchallenged certificates from the same state and must choose one. The Vice President's legal counsel, according to our scenario, has spent the preceding 72 hours working through every available constitutional text, every piece of legislative history from the ECRE, and every relevant precedent. Their conclusion, delivered in a private memo that leaks to 3 major outlets within hours, is that the Vice President has exactly 2 legally defensible options, and one that is not legally defensible at all. The option that is not defensible, choosing based on which slate benefits the Vice President's own party. That would convert a ministerial function into a partisan one, exposing the entire count to immediate legal challenge and almost certainly triggering a constitutional crisis deeper than the one the proceeding was meant to resolve. The first defensible option, defer to the Supreme Court's technical affirmance. Slate B was the operative ruling, however fragile its legal reasoning. Count Slate B, this has the advantage of following the formal judicial output, even if that output was procedurally rather than substantively grounded. The second defensible option, refer the matter back to Congress for a joint resolution, arguing that the simultaneous survival of 2 objections constitutes a structural ambiguity the ECRE did not anticipate, and that requires legislative clarification. This option has the disadvantage of having no mechanism, the ECRA contains no referral procedure. The joint session has no pause button built into its rules. And the clock, the fixed constitutional deadline for the count, is not flexible. The vice president chooses option 1. Slate B is counted. Candidate 2 receives Arbor's 12 electoral votes. Candidate 2 reaches 271. The count concludes. Here is where the scenario does not end. Here is where it accelerates. Within 4 hours of the count's conclusion, Candidate 1's campaign files an emergency application to the Supreme Court, arguing that the vice president's decision to count Slate B was itself an unconstitutional exercise of discretion, that by choosing between 2 surviving slates, the vice president exceeded the ministerial role the ECRA defined. The application asks the court to either void the count and order a recount under judicial supervision, or to declare the election unresolved and remand the question to the House of Representatives under the 12th Amendment's contingent election provisions. The Supreme Court, still deadlocked on the underlying merits, faces a new question. Did the vice president's tie-breaking choice constitute an ultra-vires act? 3 justices who previously ruled procedurally now believe the post-count challenge is justiciable. One of the 4 who ruled for Slate B on the merits believes the vice president acted correctly. The math shifts. 5-4. The court agrees to hear the emergency application. The country is now in a situation where a presidential election result has been certified by the vice president, announced to the joint session, and immediately placed under active Supreme Court review, all within the same calendar day. This is the consequence matrix that the scenario generates, and it operates on 3 distinct levels simultaneously. At the institutional level, the scenario exposes a genuine gap between the ECRA's ambitions and its architecture. The act was designed to remove human discretion from the counting process. What it could not fully remove is the discretion required when the process itself produces an ambiguous output. Every reform that narrows one vulnerability creates a boundary, and every boundary has an edge. The ECR's edge is the simultaneous dual slate survival. The drafters saw it. They assessed it as improbable enough to leave unaddressed. In our scenario, improbable became actual. At the judicial level, the scenario forces the Supreme Court into a position it has historically tried to avoid. Deciding the outcome of a presidential election after the count has already formally concluded. Bush versus Gore stopped a recount before it produced a result. This scenario asks the court to reverse a result after it has been publicly announced. The political cost of doing so, the damage to institutional legitimacy, is categorically different. And the 4-4 split that created the problem in the first place still exists within the court. Adding a 5th justice to a procedural question about vice presidential authority does not resolve the underlying substantive disagreement about which slate was valid. At the democratic legitimacy level, and this is the pressure point that matters most for the next 6 months in our scenario, the crisis is not primarily legal. It is perceptual. Half the country believes candidate 2 won. Half believes candidate 1 won. Both halves have a Supreme Court opinion, however fragmented, to point to. Both halves have a procedural argument. Neither half is obviously wrong about the facts of what happened. The system produced 2 valid answers. That is not a failure of bad actors or fraudulent intent. It is a failure of architecture. And architecture failures are significantly harder to narratively resolve than misconduct failures, because there is no villain to point to, no corrupt official to remove, no single decision to reverse. The specific upcoming pressure point to watch in the scenario, and frankly, in the real world, is the contingent election mechanism. If the Supreme Court voids the vice presidential count, the election goes to the House of Representatives, where each state delegation casts 1 vote regardless of its size. California and Wyoming each get 1 vote. The delegation composition at the time of the contingent election determines the outcome. In our near future scenario, the House delegation math favors candidate 1's party. The popular vote and the original electoral count favored candidate 2. The contingent election, if triggered, would produce a winner who lost the popular vote, lost the initial electoral count, and won only through a procedural mechanism that most Americans have never heard of, and that was last used in 1824. Whether the system survives that outcome Whether the winner of a contingent election is seen as legitimate by a sufficient majority of the public to actually govern is a question that no constitutional text can answer. That is ultimately a question about civic culture, institutional trust, and the willingness of political actors to accept outcomes produced by a process they didn't design for the circumstances they're in. The Electoral Count Reform Act was passed because January 6th demonstrated that the old framework was too fragile. The scenario we've walked through today suggests that the new framework, for all its genuine improvements, has its own fragility, one that lives at the intersection of divided state governments, close popular vote margins, and a Supreme Court that cannot find a majority when it matters most. The question that this scenario leaves open, the one worth tracking as the real-world political environment develops, is whether Congress will move to close this specific gap before the next election cycle creates pressure to test it. The window for that kind of preemptive reform is always narrowest precisely when it's most needed. In the middle of a contested political environment where any proposed fix is immediately read as partisan advantage seeking by whichever side believes the existing ambiguity favors them. Watch for any movement on electoral procedure legislation in the next 18 months. Watch for Supreme Court vacancy dynamics that could shift the 4-4 split into a working majority on electoral jurisdiction questions. And watch for state-level legislative activity in competitive swing states where divided government creates the preconditions for the dual certification scenario to move from hypothetical to procedurally possible. The 50-50 vote happened in a scenario. The architecture that made it possible is not fictional at all.